Baroness Nuala and Claire McGuigan. Could you introduce yourselves and say what your role is, Sir Iain?
Good morning, thank you, Chair. My name is Iain Livingstone. I'm currently the head of Operation Kenova. It's a position I inherited from John Boutcher in October of 2023. Prior to that, I was a police officer in Scotland for over 31 years. Latterly, for the last 6 years of those, I was the Chief Constable of Police Scotland. I retired from that role in August, and then 6 weeks later, I was back in to pick up the Kenova. So that's my position and my role, and thanks for the invitation this morning.
Thank you. Baroness O'Loan.
Thank you. I'm Nuala and I'm a member of the House of Lords. I was the first police ombudsman for Northern Ireland. I am a member of the Operation, and have been since I think 2015, a member of the Operation Kenova steering group. I am also a member of the McCulloch Review into surveillance of journalists and lawyers. I chaired the Daniel Morgan panel, which was a 6-year inquiry into the Metropolitan Police. I've done various other things in Northern Ireland, like being on a committee that watched and managed and reported on the debriefing of the UVF loyalist Gary Haggerty, who admitted to 200 crimes, including murder and stuff like that. Following my McCord report, so I've a little bit of experience around Northern Ireland.
Thank you.
Morning, John Boutcher, currently the Chief Constable of PSNI. Took up that role in October of 2023. Previous to that, I was the lead for Operation Kenova and handed over the reins to the very capable hands of Sir Iain in that October. I'd run Kenova, which I was commissioned to do by a previous Chief Constable of the PSNI, Sir George Hamilton, in 2016. We began Kenova properly in 2017. At that period, I was the Chief Constable of Bedfordshire Police. But the majority of my career has been involved in tackling serious and organised crime and terrorism. I'm the ex-head of covert policing in the guise of the Regulation of Investigatory Powers Act, which deals with agents, CHIS, surveillance, and I was also the head of undercover policing for Policing for England and Wales. I'm very happy to be here today. Thank you.
Thank you. Claire.
Hi, I'm Claire McGuigan. I'm Detective Chief Superintendent in the PSNI, and I'm in charge of legacy and disclosure.
Thank you. Chief Constable Boutcher, thank you for the response to my letter, which has been published. It's very detailed, very powerful. What, in your opinion, should meaningful engagement with the government look like?
Well, thank you for the easy opener. So, listen, what I would say, since I wrote to you, I've had 2 meetings with the Northern Ireland Office Legacy Lead and the Permanent Sec for the Northern Ireland Office, which is really encouraging. One of those meetings was last week. But because of the considerable experience and journey I've been on with regards to legacy, I had hoped, and obviously I'd sought, to be involved in helping try to find a way forward with legacy because of the experiences on Kenova. And I think it's important, if I may, just to set out very briefly some history here that predates me, but with the signing of the Good Friday Agreement, nobody gave up more with regards to the sacrifices of what had occurred during those difficult years than victims of the Troubles in Northern Ireland. Legacy was, I've described it as the unwritten chapter of the Good Friday Agreement, but it was a wickedly difficult problem to deal with. So it's perhaps understandable why it wasn't at that stage. Then we have, in 2014, an agreement, predominantly agreement by most people, most parties, 4 out of 5 of the major parties in Northern Ireland, the Irish government, around the Stormont House Agreement. And even on that process, and I remember when I started Kenova, there was a public consultation on draft legislation that was issued, which I responded to, which was, I think it was about 2017, 2018. There were 17,000 responses. Then, unfortunately and unexpectedly, the British government went unilaterally in a different direction, which was really tough for victims and stakeholders in legacy. And we then got a command paper in July 2021 that I would invite you all to re-look at, which is extremely challenging around victims and what they are seeing as they see an opportunity to finally get truth, reconciliation, justice, all sorts of different descriptions of what different people want. And the command paper was really, really difficult read for them around the mechanisms that were going to be closed down. And that was the precursor to the current bill. So with the election last year, and I know in January of 2023, the current Prime Minister said that they were looking to repeal and replace the legacy legislation. I think the level of engagement generally has not been what people would have wanted. And I offer you this. I wrote the Kenova report, and in that I describe how numerous previous inquiries had suffered because of a lack of disclosure, challenges around national security. The stakeholders who seem to have the most influence in legacy are lawyers, government lawyers. And it's those very lawyers and those very institutions, of which I'm the Chief Constable now of the PSNI, and I'm very defensive around how the security forces generally operated during the Troubles, because I think they did a remarkable job. But what we've done since the Good Friday Agreement is try to put brick wall after brick wall in front of information provision. And it feels to me like the unilateral approach by the last administration was a final high wall to stop information coming out. And the engagement that I would have expected, the open consultation that I would have hoped for, hasn't occurred as any of us would have wished. And I think the Secretary of State, the Northern Office, have a strong relationship with the lawyers who've helped draft the bill, who are part of the problem in understanding all of the different viewpoints, experiences and needs of society in Northern Ireland. But I genuinely believe this Secretary of State wants to get this right. But it's taken some time to do that because it's clearly a very difficult journey to go on.
Thank you. We appreciate your candidness. Sir Iain, have you had engagement with the Secretary of State in the Northern Ireland office on how legacy structures could be improved?
I haven't directly, Chair. I have met with the Secretary of State for Northern Ireland and his officials a number of times, but it's mostly been to do with issues I've had with bringing Kenova to a closure. Primarily the significant issue around material that had been withheld by MI5 as a matter of public record, and the implications from that, and the circumstances around that. I've also written to the Secretary of State seeking an update on the 10 recommendations that were included in John's interim report, as well as specifically asking and seeking authority to name the agent steak knife, again an issue that was raised in some detail in John's report. But on legacy, perhaps because we're busy with other material, I actually haven't had that discussion with either the Secretary of State or his officials. And again, candidly, it's something I'd be more than happy to do, because there is an element of, I'm not quite an independent third eye, but there's part of that. I've been involved, as Nuala has, with some of the oversight boards right from the outset. I've had previous experience in working in Northern Ireland, but I'm not immersed in it. I come from another jurisdiction. There's different structures and processes, so I'm more than very, very happy and I suppose would be motivated to make a contribution. But I actually haven't had any specific discussion or consultation on legacy matters with either the Secretary of State or his officials.
That would be useful in your opinion?
All due modesty, I think I would have a contribution, another voice, and as I said, because I would have a perspective that's informed but distant at the same time, if that's not too contradictory.
Yeah, okay, I understand. Okay, Baroness O'Loan, in your view, what is your view on the government announcing that it would retain ICRA before formal consultation processes had begun? And what is your view on the government's overall approach to the consultation thus far?
I think it's marked by confusion and contradiction. because it's almost as if there are two sets of language being used and they don't mean the things that the other side thinks they do. So if I say, for example, the Secretary of State said that he would repeal the legislation, and then he has talked about amending it, and then talked about keeping ICRIR, and then talked about everything being up for discussion. But I think they're still talking about repeal, but it's very clear that there is an intention to keep the ICRIR. I think that would be the wrong thing to do. I think, the Secretary of State said in December, he said, I can announce that I will introduce primary legislation when time allows, and that went quiet. And then we had we had the draft remedial order, and I actually tabled a motion, a non-fatal motion in respect of that in our chamber, and that's the only discussion of that there's been. And we don't know when the remedial order is coming back, and we don't know in what form it's coming back. So, and they used the non-urgent procedure for the remedial order, which I think is significant because it says it's not urgent, but actually for those victims who maybe have civil actions or who have other issues, particularly the inquest victims' families, it is urgent. It really is urgent. And there were people in the middle of inquests and in the middle of civil actions, which they had started in the hope they'd be able to run them through, but they haven't. So I think the uncertainty about inquest processes is very, very unhelpful. I understand that the Secretary of State feels he must clarify legal positions, but I think the current number of actions which are before the court are sending a message about disclosure of information which isn't helpful at a time when the ICRIR is supposed to be set up to deliver all the information in a way that nobody else has ever been able to deliver it before. So I think and I'm not aware of any real consultation. I know that government are talking to various organisations like the Human Rights Commission, as I would expect them to, but there's no body of suggestions on the table upon which people could comment, no formal consultation. So it's a very peculiar situation in which I'm not sure, I'm sure the committee are much better informed than I am, but I don't actually know what's happening or what's really proposed. And the problem is, I think that generates suspicion in the community in Northern Ireland, and that is not helpful at this time.
Thank you. Gavin Robinson.
Thanks, Chair. Good morning, everyone. Chief Constable, I think it's fair to say that you have been brutally but appropriately frank about the financial situation that PSNI is in. It was one of your predecessors that lamented the fact that police are spending so much time policing the past, that it's having a fundamental impact on the ability to police the present. Could you contextualise for us the cost of legacy to PSNI and what impact it has on your operative budget at the moment?
Yeah, and listen, thanks for the question, because this is an area, again, where any government approach to legacy has got to factor in all the different limbs, all of the different consequences of legacy being addressed. And I would suggest there isn't another organisation that has such an important attach to it as the PSNI with regards to legacy, because this is about trust and confidence. When the PSNI was formed, it was a forward-looking organisation, community-based, seeking to be representative of all the communities it policed, human rights focused. And I've had a number of discussions about what arrangements were in place when policing was devolved in 2010 to the Executive in Northern Ireland to deal with legacy. Now, in fairness to the Executive and others, I don't think in 2010 they probably expected legacy to still be such a challenging issue, and it's a cross-cutting issue in Northern Ireland. But there were no arrangements or agreements around how legacy for the PSNI would be funded. And to give you some figures, we have a legacy investigation branch that was the successor organisation or unit to the HET, the Historical Inquiries Team. That unit costs £5.3 million a year to fund. We also have ongoing civil cases. So that's criminal investigations are dealt with by the Legacy Investigation Branch. We have ongoing civil cases. So that's over £3 million a year that costs us to deal with those cases. And to give you another snapshot of why this is, frankly, it's quite a mess, and it continues to be a mess. And obviously, I think we're in a unique place, opportunity-wise, to try and resolve this. Between 2018 and 2024, the PSNI resolved 30 challenging civil cases. In those cases, we paid out to families, claimants, victims, a total of £25 million, which we're not funded for. Of that £25 million, though, I'm told that £7.3 million, so I'll repeat that, £7.3 million went to the victims, the claimants themselves. £17.7 million went to the lawyers. Now, because we have this attritional approach to legacy by all the security agencies around information disclosure and provision, it creates a greenfield site for lawyers. And this is public money. And it's public money that the PSNI is not funded for. So that's taking money from contemporary policing, and you, I know very well, know the challenges we have with paramilitaries, trying to police a post-conflict society. We need to be in schools, communities. We had incident on Monday, 50 petrol bombs thrown on Easter Monday, children being criminalised. And we are not where we should be, because we spend so much time looking back at the past. And some of the figures, and I'd very much like just to bring Claire in because some of the details, some of the figures around what we're probably spending now, and year on year it varies. We're spending around, we're just over £20 million a year now. That would be about 400 police officers. But we've been left with this millstone, this anchor that holds the PSNI back, because families, victims, on all sides of the different victims' profile, see that lack of action as our fault, our responsibility, and it genuinely isn't. We are trying to design a plan now to go to the Secretary of State, to go to the Executive, to try and make sure that they don't just think about the ICRIR, they think about actually moving society in Northern Ireland forward by trying to help the PSNI do what we were never intended or designed to do by dealing with these legacy issues. So it is a considerable burden on us. And trying to get a conversation about where we might get that funding, the current financial climate, because of what's happened globally, the geopolitics, is really tough. The Secretary of State will send me to the Executive will send me to the Secretary of State. But this was during direct rule that these cases occurred. But we're left trying to address them. And I want candour, I want openness, but I haven't got the people to provide that sort of response that I need because of the lack of any funding. But can I just ask Claire if she wants to add anything on the details of that?
Yeah, I mean, I think it's also important just to recognise that the Department of Justice did give us some funding, and that was for the 5-year plan on inquests. And I think if you look at the Stormont House Agreement, where it did say inquests would continue and the Executive would ensure that there was funding provided for that, you can see that. But really, apart from that, the PSNI has had to find the funding from our own budgets in order to deal with that. So over the 7 years, if you look at the investigations that we have done, if you look at the civil actions in terms of resourcing them and the compensation, it's cost around 126 million in totality. So that's quite a significant amount of money. Breaking that down, you're into 18 to 20 million, and I'm anticipating that the legislative changes are likely to add to that. Nothing has stopped because of the Legacy Act. We still have investigations to continue. We still have the civil claims. We have over 1,100 civil claims to deal with. We don't have anywhere near the resources to actually research and deal with those, nor the money to settle them. So we're really in a position that is very, very, very difficult, and it doesn't build trust with the community because it looks like we're stalling, we're taking too long to do these things, and of course then it's because we don't want to disclose, but we simply just don't have the resources. To get those resources, I'd have to take even more out of contemporary policing. I'd have to go and ask for people to be moved out of contemporary policing to come in to deal with legacy. So nothing has stopped with the Legacy Act, but the provisions within it are likely to put statutory obligations onto the police service in Northern Ireland, and with that and public inquiries that are legacy related, I think we're looking at another 4 to 5 million on top of that, on top of what we're currently spending. Nothing has stopped for the PSNI.
Rather than consider this in the round and talk about the potential back and forth between executive, NIO, your own budget, I mean, this is an opportunity for us as a committee to have this inquiry and to make recommendations to government. And so maybe I've asked for a PSNI response, and then perhaps Dame Nuala and Sir Iain, just to give us your view as to how the NIO should consider the appropriate funding of whatever legacy mechanism they land on, but also the legacy bits of legacy that rest still within PSNI.
Well, I think it's what I just said about it feels like all their eggs are in one basket. And Claire alluded to the legislation as it is, and of course we pointed this out. There's a requirement, and this is the lawyers again. It's the lawyers who have a disproportionate influence in all of this, and I think are on a particular side of things. And I understand, by the way, these are good people, but I think they've lost perspective. My background should tell you I try to bring a really balanced view. I am not going to put any lives at risk. I'm not going to breach national security. I'm trying to do everything really responsibly. There seems to be a disproportionate response in Northern Ireland, and since I've arrived as Chief Constable, the committee will be aware I've tried to change some of that, and that those changes continue around openness and transparency. But with the creation of whatever the Commission will look like and whatever units are in the Commission, because there's discussions about whether reconciliation, truth recovery should sit outside or inside, and they should just concentrate on investigations, there will be significant implications for us of that Commission and that work going forward. When we talked about those civil cases, in 2014 there were 150 civil cases that the PSNI had with troubles-related cases. The end of 2017-2018 that went to 850. It's now, as Claire said, it's over 1,100, and because of the remedial bill that the Secretary of State announced in December, opening up civil cases again, which in many ways I welcome to try and deal with these issues, but that number will only increase. So my plea to this committee is to ask them to take a whole systems approach to legacy, not a narrow approach to legacy, not a narrow approach to consultation, to genuinely, authentically take a wider approach and listen to everybody's voice and understand the different mechanisms of legacy. It's not just about the Commission.
Thank you. Baroness Malone, you have an experience in this in many regards with police ombudsman work and with the steering group of Operation Kenova and others. So do you feel that there's an appropriate way in which the NIO should approach the financing of these investigations?
I think there is a way that perhaps might help everyone. I'd just like to take you back for one moment to the recommendations in patent for the policing complement for Northern Ireland, which, if I remember correctly, was 7,500 officers for a population of 1.5 million. We now have a population of nearly 2 million, and I can ask the Chief Constable if he can remind me how many officers he's got, but I know it's way below that.
We've now got 6,300, and one thing, and I know Baroness O'Lone knows this, and I speak to Chris Patton, that additional resilience that Chris Patton provided was 2,500 reserve officers. That's gone. And that was to scale up in times of crisis. That's gone. So we are down to 6,300, which is dangerously, dangerously low.
And I think the consequences of that and the consequences of the things that Mr. Boutcher and the Superintendent have told you is that there are very high levels of sickness and other problems. for the officers who are trying to provide a service today, but many of whom have been providing that service for 20, 30 years. So they are people who have lived through so much in policing terms. My understanding is that at the current moment there's no PSNI funding for legacy cases, so that there isn't a ring-fence budget. I think that it's not reasonable that the PSNI have to take today's budget, which is calculated using various criteria, but which is clearly inadequate, in order to fund yesterday's cases. I think that's my bottom line. The reality is that these matters do derive in large part from situations in which the United Kingdom government as a whole had overall control, and they involve all the security and policing agencies, not just the PSNI. So the PSNI very often cannot act alone, and I think that means the government really need to be ready to set aside a specific budget for these matters, and in particular to ring-fence a separate legal legacy budget to cover all aspects of providing a criminal justice system to deal with the past, because the reality is our criminal justice system is quite profoundly broken. Cases are now being listed, things like rape cases being listed for 2028, 2029. I mean, for victims, the horror of that situation, for those who are accused and who are innocent unless and until they're found guilty, that is also a terrible situation. So it's not just a matter of the PSNI, it is a matter of the PPS and the whole court system and our legal profession. So there's an awful lot to fix, but perhaps we could start with a ring-fence budget for legacy.
Thank you. Sir Iain, do you have any brief comments to make on financing of legacy, or do you concur with what's been said?
I concur, and I think just to reinforce the point that it's actually beyond criminal justice as well, as we know. When you look at the OMA public inquiry, so whenever there's an announcement from one element, whether it's civil, whether it's administrative, criminal justice, actually it comes back to the police service. So the police service obligations round about disclosure, it means that if you're rightly supporting the OMA inquiry, inevitably something has to give, and the pressures are quite enormous. I've seen them with my own eyes, and I'd wholly endorse what my colleagues have said.
Thank you very much, sir.
Katrina Murray.
Thank you very much. As you'll appreciate, the committee has spent time meeting with families and the organisations which support them, and probably fair to say that all of us have been quite affected by the stories that their experiences and stories that they were telling us, probably no different to anything that you have experienced with them as well. What seemed very common was the belief that an inquest which provided answers to them was what they most believed in, as would provide some form of closure for them. But inquests are not necessarily been that easy to necessarily get, and particularly lots of those inquests will have very sensitive information. The Secretary of State has said he will legislate to ensure that those inquests which have that sensitive information and are unable to conclude through the coroner system would be proceeded through the independent commissioning. What's your assessment of this proposal? Can I start with you, Chief Constable?
So, thank you for the question, because this is a very sensitive point for many people, and it's a challenging area. You'll be aware that the Act meant that on the 1st of May of last year, all inquests, troubles-related inquests, had to stop. And I arrived in October 2023, where effectively, because of the Act, and this was really clumsy and not good for families trying to get a meaningful legacy, we had too few barristers and counsel to run those inquests. We had too few coroners. We had too little estate, because there was this sword of Damocles date of the 1st of May of 2024 when they all had to stop. So that's the first thing I'd say, the way they were all shoehorned to a full stop, which wasn't good for anybody. And I think, it sends a very negative message about how we are approaching legacy in Northern Ireland, these victims and families. There is a real challenge around sensitive information for inquests, but again, I would say this: the approaches I've seen in Northern Ireland around managing sensitive information, public interest immunity, are not as I've experienced previously. They are far stronger in their approach to requiring that information is redacted that I wouldn't ordinarily expect to be redacted. In my view, it is in no way a national security issue. And so we've changed our stance, and currently there is a draft public interest immunity policy that we've written, because there wasn't one, that we've shared with the NIO and the reviewer of terrorist legislation and the legislation in Northern Ireland that manages national security. We've shared it with them for their feedback. So I think there's much we can do to actually improve the process. The proposition to put, though, inquests into the Commission is a bit cart and horse for me, because the Commission needs to be trusted. And you don't get that anywhere else. What people talk about is parity, equality of how things are dealt with elsewhere. There is also real concerns around that, around the Secretary of State veto and the Secretary of State ultimate sanction or decision on reports that will come out with sensitive information, which is again something that doesn't happen anywhere else. So it's different, and difference causes suspicion and a lack of confidence. Now, I have no doubts about the integrity and the authenticity of this Secretary of State, but he could move, you get another Secretary of State, and you need to have processes in there that people recognise and have confidence and trust in. And inquests in Northern Ireland have played a pivotal role in giving many families the truth of what happened. No better example than the Ballymurphy inquest, where with the security forces saying one thing right up to almost the door of the court, until the inquest was brilliantly stewarded by our now Lady Chief Justice, dealing with lots of complex issues, sensitive information as well. And it's certainly worth looking at her judgment. So I think it's premature, and I think it causes more anxiety than reassurance by proposing that direction of travel.
Can I come in there? Sorry. Chief Constable, you said that you shared the PII policy with the NIO. Have you had feedback to that?
No, they've asked us for more time, I think.
Yeah, I think they're ready to meet with us to talk about it, but we haven't had that meeting just yet.
What timescales are you expecting on that?
I would say in the next number of weeks that we will meet up with them to discuss. But we haven't had any written correspondence from them or anything like that. So I think the next step will be that we'll sit down and discuss the various elements of it to see how it can work in practice.
And just so you know, sorry Chair, it's been drafted in a way that's very focused on national security and reassurances, and my position would be to publish that. So obviously it's a framework to tell you how we would do it, because we were doing it two different ways when I arrived. So we've got a single policy, and people can look at that to understand how we're actually applying it. So that's the journey, that's the aim around that.
Thank you. Sorry, continue.
That's fine. Baroness Stone.
Thank you, and thank you for the question. My understanding is that the proposal that the government now have for inquests is that I think there are 38 inquests which were stopped, which isn't a huge number of inquests in the context of a population of 68 million. So those 38 inquests are to be managed, inquired into by the ICRII using what they described as enhanced inquisitorial processes, but falling short of the full inquest processes. And the key to all this, the key to the problem with inquests is that inquests seek information and information is not delivered. And then people have to come back. I mean, I think the Brown family, who currently do have an inquest running, have been back in court something like 58 times trying to get information. Now, that is a scandal. I investigated that case 22 years ago, 23 years ago, and I remember being absolutely assured that there was no further information, but knowing from what I knew that there must be further information, and there was, and we now know there was, that further information was available. So in a statutory investigation, whether it's an inquiry, whether it's a police ombudsman or anything, it's very simple. You need to know which questions to ask. And these bodies, the PSNI, the Legacy Investigation Branch, the Police Ombudsman, we know what the questions are, we know how to frame them, we know what information we're trying to get, and when you get further information, you carry on. The problem is when you ask the questions and the doors close. And that is a repeated event. And you know, one of the things that I have noticed over my many years on this is that information is classified. So some of it's classified as sensitive and requiring particular protection. But they are trying to protect information which is not sensitive now. It may have been sensitive once. I'll give you an example. I did an investigation into the killing of the last soldier in Northern Ireland by the IRA. His name was Stephen Restorick. I'll never forget him or his parents. But in the case of Stephen Restorick, we asked for information, we got information, and I produced a report. And the report said that a helicopter was flying for a particular purpose, gathering information in a particular context. And when I published it, I was told that if I didn't take it down, my website would be taken down. So that, you know, the fact that Army helicopters collected information is something which is known to the Northern Ireland public. Otherwise, what were they up there all the time for, you know, having parties? So I'm not being flippant, but I do feel very strongly that information was often wrongly classified. It was classified for a time, but the reality is the techniques have changed. The individuals are very often dead. There is this NCND policy, which is very problematic. In fact, we had a case involving a man called Scappaticci, a judicial review case which was decided some years ago. And even then the judge was saying this is not an absolute obligation not to release information, not to confirm things. What he said was it has to be done on a case-by-case basis, having regard to all the factors which are relevant. But that doesn't seem to be the approach that's taken. And indeed I did name a woman who was accused of being an informant, Jean McConville, who was taken from her 10 children. And the world didn't fall down, and there were no major security breaches as a consequence. So we need a completely different approach to that. I haven't seen the Chief Constable's new PII policy, but I do look forward to seeing it when he's got it through the NIO and people like that. And we're being told now, and this is the problem, we're being told the ICRIR will be able to get all the information which nobody else has been able to get. Okay. Yet simultaneously, the Secretary of State is in the courts fighting to prevent disclosure of information and fighting to challenge things like the finding that the ICRIR is not an Article 2 compliant investigation, in part because of its powers in relation to next of kin and disclosure. So I think it's a huge problem, and people just don't believe that the ICRIR will get this additional information, because there's no reason why they should if nobody else could. Unless there were a major policy change by government, and there's no sign of that. And nothing in the legislation as it stands, nothing in the enhanced inquisitorial processes which are proposed would overcome the problem. There'll be no court, no independent lawyers, families won't have access to their own lawyers, and the Secretary of State, as the Chief Constable said, has power to curtail the distribution of the findings. So I think the only thing I would say is we need to reinstate the coronial process, but we do have to devise additional processes to deal with national security information, and particularly to work out what actually is national security information. Thank you.
Iain, is there anything you want to add?
I think just Baroness alone talked around when a process is initiated, you actually don't know exactly what information is available at that time. So this demarcation between a normal inquest and a sensitive inquest, I think that would be a very, very difficult line to draw, and I think it's something that might evolve once you start something. So you might start on one side of that divide, and actually as it evolves it moves over. So that suggestion I think would be really, really challenging. I think, as Baroness outlined, you would have a robust inquest system with robust processes within that to deal with sensitive information, rather than having that demarcation that's suggested.
Thanks very much.
Okay, Claire Hannah.
Thank you very much. Baroness O'Loan, just building on what you said there about disclosure and that being the context, you said in your submission to us that having announced the repeal of the Act, government has now made clear that it intends to maintain the ICRIR, which is a fundamental problem, and you later said in bold, what is required at this stage is a new institution. You wrote that in February, before the appeal on the Sean Brown public inquiry and before the appeal on the decision on the Legacy Act. Does it remain your view that ICRIR is widely rejected, and can you reflect what you're hearing from victims and survivors about that body?
Yeah, I was with the victims on Palm Sunday, the Sunday before Easter. The victims, the families of the disappeared, and a certain amount of discussion among them, and distrust that I've found in other situations with working with families. People will say to me, very few people have said to me, I'm going, but it's because there's nowhere else to go, and it's not, the expectation is nothing will work. And the number of people who have actually gone to the ICRIR, I think, is indicative of the fact that people don't trust it. I said in my submission, I think, that we got 3,000-something cases in the first year, a lot of them legacy cases. That hasn't happened for the ICRIR. And I think part of the reason is the way it's set up, part of the reason is the powers that it has, and part of the reason is that the courts have confirmed that the processes are in breach of Article 2, and that the investigation, I think the major problem is that when you think about it, I know we're going to talk about reconciliation later, but investigation is not a reconciliation process. Investigation is a process by which you take a set of facts, consider them, look for investigative opportunities, find all your evidence, bring it together, analyse it, etc., etc. You can't have a criteria that says we're going to use reconciliation as a criteria for deciding which cases we're going to deal with. I just don't understand it at all, and it doesn't seem awfully sensible to me. And we do know that limiting, if you look at the title of the Act, the title of the Act says that the purpose of the Act is to limit criminal investigations, legal proceedings, inquests and police complaints. Now that is not calculated to promote reconciliation. I'll come back to reconciliation later. What I think we need is to separate investigation and information recovery. I've said that there should be a new body. I suspect that what we actually need are what the Stormont House Agreement proposed initially, which was two bodies. What I would call a Legacy Investigation Commission, which would deal with investigations, and an Information Recovery Independent Commission, which would deal with situations in which there is no possibility of prosecution, where there's no evidence, but where it may be possible to delve, even among open sources and things like that, but more particularly among information which is not going to lead to a prosecution, but which would help victims. And I think that if you had two separate commissions, the purpose to achieve reconciliation, which is the primary duty of the ICRIR, is to promote reconciliation. That's done by all sorts of things around trust and understanding and knowledge. And I think that before you get anywhere near reconciliation, you need to build understanding and knowledge. And I think that's why this information recovery thing is so important. But I think that the rule of law requires that we have a process which is not circumscribed by legislation, and in which investigators can do the job that they do in all the other cases of murders and serious crime in the rest of the United Kingdom. I don't think that if we did have an independent commission for information recovery, I don't think it should involve any form of amnesty, but I think you could have something modelled on the ICLVR, the Commission for the Location of Victims' Remains, a process by which information could be provided either anonymously or otherwise, which could then be examined and verified if it's verifiable and then brought into account. I don't think, too, that the ICRIR should be considering reconciliation when it's working out what it's going to tell people, because people need to be told what there is. It is not for those in command or in control of investigations and information recovery to decide what it's in a person's interest to hear. I have always taken the view, and I did it starting so long ago with the Oma victims, you tell them what there is to know. You show them the evidence that supports why you've said what you've said, and then you provide the support that enables them to deal with it. But you do not withhold information, because one of the problems we have is, of course, archives disclose information, journalists know things, witnesses tell things, and Mo Moldham had a phrase. She used to talk about the dogs in the street, and there is an element of that. But people need to know, and they need it to be confirmed by bodies which have the respect of the people. And I don't think that the ICRIR is so formulated to enable it to earn trust and respect in respect of its processes, because they're not independent. It has no power to release information without sensitive information, without consulting the Secretary of State. We'll talk later about its powers to access information, but there are an awful lot of problems.
In regards, and you've addressed a number of the things I was going to ask, but in regard to sort of separate and firewalled pathways for information retrieval and for investigative processes, can you give an assessment of the need for accountability mechanisms for non-state actors, and perhaps comment on how that might affect that issue of narratives about what happened in the Troubles?
Yeah, I mean, I think there's this kind of narrative that goes that the IRA didn't keep records, the PSNI did keep records, therefore we can find out what the PSNI did, but not what the IRA and the UVF and the UDA did. And that is true to some degree, but the reality is the PSNI and the MOD and people like that have an awful lot of information which is verifiable about what the IRA did. And most of the people who have been prosecuted are members of paramilitary organisations. So I think that the processes that Kenova used, and I think John and Iain probably talk much better about this than I can, but they were talking to people who were very close to what we might call the action, and they did recover information and find things that way. So there's an investigative path there, and there's also the ICLVR path where their bread and butter business is finding bodies, but in order to find the bodies they need information from the people who know those who buried the bodies or who buried the bodies, and they too have been successful in finding bodies because people have finally come forward. But I think that both John and Iain would be in a better position to talk about talking to paramilitaries. I have spoken to paramilitaries on all sides, and it's just part of business. It's something you have to do, and it's not difficult or challenging.
Can you comment on what would be required to facilitate full participation, or I suppose synergy, for want of a better word, for the Republic's investigations into legacy and their authorities?
I think it's profoundly difficult. I think that, the recent signing of the agreement with the Oma inquiry is indicative of a will to assist. But an awful lot of the crime which occurred actually occurred in planning terms in the Republic of Ireland, and an awful lot of information is held in the Republic of Ireland, and it's a bit difficult to get that information out. I would have expected, and I said that the Republic should have established some sort of an independent inquiry on Oma to run parallel to our Oma inquiry, because there's clear evidence that that one was planned down there. But this is repeated across so many incidents in the Troubles. I think that there needs to be probably legislation in the South to enable the transmission of intelligence and information which the Republic holds. I think they would need some sort of commission which would, at the very least, assist the working of whatever we end up with in terms of a legacy investigation commission. There are very difficult jurisdictional issues to that. There are difficult political issues to that. But but we have to be innovative and find new ways.
Chief Constable, can you understand the view as well that in light of the appeal on the Sean Brown inquiry, the appeal on the legacy ruling, suppose circling the wagons a bit on Thompson, and even potentially, as we might touch on, holding back aspects of Kenova, can you understand the view that it is still and increasingly security elites in the driving seat on this legislation, or at least the needs of security elites?
So I think that's what I said at the beginning. There's a disproportionate influence by people who have continually sought to take a protectionist view around information. In the Kenova report, I talked about various people who dealt with legacy over recent years. So Dave Cox from the Historical Inquiries team, who talked from the PSNI perspective that they only ever gave him a limited version of the truth. They never gave everything that they should have given. And by the way, these were conversations I had with people before I was before this committee in 2021. And I just said, look, if you were sitting next to me, what would you want to say? And, you know, the HET did some really good work. I know some people didn't feel that the HET provided them with the answers that they wanted. And we know the HET didn't get all the information, hence Dave's comment. The HET did not get the information that they should have got. Some of that's linked to the Sean Brown case, as an example of that in that case. We're trying to put that right, by the way. There is a genuine intention to correct that. But if you also look at people's views on that, it's not just now. And a lot of this is so driven by the people in the background who aren't sort of out on the pitch. And I'm asking them to talk to me and explain why there's national security concerns about this, because I will listen very carefully to anything they say in case it would influence my position. But those previous people who do those inquiries, Lord Stevens said that he was deliberately misled. He said he was criminally obstructed by the police and military, and he said MI5 withheld information from him. I mean, these are you know, people who've been commissioned to do lawful investigations at great public expense to provide families with answers, and we continually fall short because information isn't ultimately provided. Rennie Pomerantz, who was the deputy to Judge Corey, I would have spoken to Judge Corey, but he wasn't well, and Rennie Pomerantz describes how, and it was MI5, made her job really difficult. It's in the report. Her quote of what was said was in the report, which I shared with MI5 for accuracy purposes. And they made their job as hard as it could possibly be. And she actually says, and this is something that just gets missed, that the security forces consider themselves above the law. We are not above the law. I genuinely think we've got this strategically entirely wrong, including their approach to legacy and consultation from the first question. The security services, the security forces during the Troubles did an incredible job on everything I've seen, but we got things wrong, and at times we had criminals in the security forces. It sets us apart as a democracy when those agencies are questioned, when allegations are made as to how we respond to those allegations. The way we've responded to those allegations, I think we would call out internationally if another country did it. And I just feel it's about time, and I have great expectations with this administration that somebody will suddenly start to listen and realise that these people have been saying things for a long time. Judge Smithick, I met Judge Smithick, exactly the same issues around how difficult his inquiry, south of the border, which came from the Corey piece of work, was obstructed. And Mary Laverty, his senior counsel, said, when will they decide that this is not national security issue? Now, I don't know when that is, and there will be, by the way, it's really important to say this, there will be national security issues. And there is a real and important reason why we have NCND, neither confirm nor deny, that we have mechanisms to deal with sensitive information, tried and tested mechanisms that provide reassurances about how that information is dealt with. There are mechanisms to ensure that the balancing exercise of competing public interests are addressed. And that mechanism is the judiciary. It's the judiciary. It isn't people in corridors behind closed doors. And this is a guy who's had a covert policing and have applied NCND and have given evidence at all the main courts and done so much public interest immunity with judges around sensitive information. I just think we've got this in the wrong place. I'm not so the questions you're asking, I've not been asked around. You spoke to Baroness O'Loan there about should there be a separate information retrieval body from the investigative body. In my view, there should be. I think the Commission, as it currently has been designed, doesn't know if it's one thing or another. And investigators, from my understanding, are not actually going to get access to families because there's a whole other process to go through first. Well, Stormont House Agreement did a reasonable job of setting out how those two bodies would work together. The investigative body would provide the information retrieval body with its findings. And there was this reassurance to people who came to the information retrieval body that there would be no criminal or civil proceedings against them for what they told that body. And there's something in the Dillon judgment, Justice Coaten talked about the fact that families are never consulted about whether they would agree to immunity or not to get information. There are so many aspects of legacy that it feels that people just haven't factored in because there's been such a disproportionate approach to the legislative approach and the lawyer approach. And I'll finish with this on Kenova. We made so much progress, I think. We did stuff that hasn't been done before because we learned from those other inquiries I mentioned. But it feels when I read the bill, my heart sank, that the bill was designed to stop the progress that Kenova had made. So whenever I heard people saying, this is a Kenova approach, the bill, be very clear, I built Kenova. The bill is not a Kenova approach. Let's be absolutely clear on that. It is not. But we can still, I think we can still recover this. As I say, I'm really optimistic around what I think this government is intending to do, but we need to see what that looks like, and it needs to be consulted upon.
You built Kenova, and it is associated with, I suppose, a degree of confidence from families that other investigations didn't have. Would you agree with Baroness O'Loan's written comments that ICRA has been widely rejected?
There's no doubt it has been widely rejected. I don't think that's really up for debate. But we need it to work. I want the Commission to work, or whatever the Commission looks like. Whether we do the repeal and sort of replace, but we need to do something that we get the families' trust back. And at the moment, not asking the right questions, not engaging in the right way, other than trying to be protectionist and reassure the lawyers, right, we'll do X, Y and Z around information provision. There'll be other, if you like, safeguards for you around vetoes with the Secretary of State. All of that, I understand, and of course they need to consult on that. But that has set a path where there's just no trust and confidence in this process. And at some point, somebody's got to call time. Now, I think that's what might be happening, but time will tell on that.
Thank you. Thank you, Chair.
Okay, Gavin Robinson.
Thanks very much, Chair. Baroness O'Loan, you mentioned in response to Miss Hannah the political and jurisdictional difficulties around OMA inquiry particularly. And we're aware that a memorandum of understanding was published within the last fortnight between the OMA inquiry itself, its chairman and the Irish government. You've read that?
I haven't read the agreement, no, I haven't had time yet.
I think you're right to mention that they will have to legislate on the provision of intelligence information. But as it stands, the Memorandum of Understanding is in line with the terms of reference of the OMA inquiry, which is to assess whether the UK authorities could have prevented the atrocity. So there's no introspection in that, and this committee has heard from CAJ, for example, who published a report at the end of February of this year, citing the fact that the Irish government themselves have been completely devoid on the creation of investigatory bodies, legacy bodies, provision of information, extradition of participants or perpetrators. So whilst you accept that there are political and jurisdictional difficulties, do you believe that the Irish government should be doing an awful lot more, and particularly in OMA, not assisting answering a question as to whether the UK authorities could have done more, but also a level of introspection to recognise whether they themselves could have done more to prevent the atrocity?
I absolutely do. It would have been remiss of An Garda Síochána if they had not been gathering intelligence and information about the activities of terrorists, of IRA people, particularly in their jurisdiction, and they were gathering such information, and it would be imperative that such information is shared. And if we look at Omagh, for example, we know that the bomb which came to Omagh and which exploded came up from the south. And we know, I think there's been too much of a process by which assurances have been given that, all information will be provided, etc., but when you go back and ask for the information, it's not provided. I'll give you one example in the context of Omagh because it really struck me as being a very interesting approach. I was approached by a Garda officer who was a whistleblower effectively and who brought information to me in 2003 or something. I can't remember the exact year, sorry, but early on. And he produced a mountain of evidence to support his allegations that the Irish government were actually tracking some bombs, though not the Omagh bomb. I took that information to Dublin, and a commission of inquiry was established. Now, that commission of inquiry never sought to hear evidence from the senior investigating officer on the Omagh bomb inquiry. And when I went down, and when I was invited to give evidence, and I went down, I asked them one question. And my question was, do you have access to Garda Special Branch material? And the answer was, no, we don't need that. This is a CID matter. And that I knew then that committee of inquiry would produce nothing. So I think there needs to be a really serious look in the Republic of Ireland, and I know how difficult it's going to be, because I know that the dynamics, the constructs, the contexts are difficult, but there actually does need to be a determined process through which the records in the Republic of Ireland are made available where necessary so that the Omagh bomb inquiry can do its work. So, thank you.
Thank you very much for that response. Thank you, Chair.
Chris Blow.
Thank you, Chair. Thank you. This has been an incredible set of evidence that you've given, and it's been really forthright and candid, so I really appreciate that, especially as someone who's new to this committee. You've made lots of comments about ICRA already today, and in previous evidence sessions we've heard about the limitations and obviously read some of the things that all of you have put on record as well. And I'd be interested to know what changes you would recommend to the rules of referral of cases to ICRA, and could this contribute to that? You already mentioned your concerns about trust and engagement from family members, but do you think that could improve engagement with the Commission? And the follow-up question to that would be, ICRA currently has no power to initiate its own investigations. Should it have that power, and if so, why? And happy to start with whoever wants to go first.
I'll go and try and be briefly. Taking your final question first, yes, it should. I think that's just an intuitive. They will find something that only they can read, and that would cause them to initiate an inquiry. It'd be totally counterintuitive for that had to be then referred back to the Secretary of State or the Attorney General or whatever. So yes, I think that's an absolute requirement. And then the first question is, I think it should. I think, as I understand it, neither the Chief Constable nor the DPP in Northern Ireland have the ability to refer matters in. So there is no 35-5 equivalent, which was the foundation upon which much of Kenova stood. So I do think the bodies of referral need to be extended, and I do think that the Commission should have the power to self-initiate.
Yeah, I mean, I have absolutely no doubt everybody else has a power to self-initiate when they have suspicions that a crime may have been committed. In my early days as police ombudsman, there were some difficulties with judges wanting to refer to me and people like that, and those had to be dealt with and were dealt with. So yes, of course, they should have a power to investigate without a referral. I mean, the biggest reason for that is that people are so afraid. They are afraid of coming forward to give evidence against those who may have murdered their loved ones, because paramilitary organisations still exist. and their adherents still exist, and they will threaten people and worse. So the power of self-investigation, initiation of investigations is definitely necessary. I think another thing that would help is if people could simply come forward and make a very simple statement and they shouldn't be asked what they want to need to know. That's part of a family liaison process, but it kind of circumscribes the expectations both of the public and of... I remember hearing one case of one individual who'd gone to ICRIR and had been asked, well, what is it you want to know? And he wanted to know something about the final moments of his loved one. And yes, that's what they want to know. But actually, when you come back then, you end up in a situation in which they want to know so much more. So it's better to start off from the right place, if you follow me. And if I can go back to that thing about people coming, I can remember a lady coming into my office as police ombudsman to complain about her son being murdered, and she knew who'd murdered her son, and she couldn't tell me the name of the person who murdered her son. She was too afraid to hear the words coming out of her mouth. We've come a long way since those days, but people still live in a degree of terror when that's been their experience, and people are still subject to vilification and attack when they seek to find out what actually happened. So I think, yes, and I think there should be an automatic expectation that the report which is received by somebody who has been the subject of, or whose loved one's death has been the subject of investigation, should receive a full, absolute report, subject only to the requirements of national security.
Thank you. Listen, I think it's been covered. When I was doing Kenova, we came across information that required being investigated, and I spoke to the then chief constables, and we then investigated those cases because of what you identify. I've written to the Secretary of State about other cases I'm concerned about, who said that, well, they can be dealt with by the Commission, but not if the families don't refer them. He has to refer them in. I wasn't able to refer them. So firstly, the Commission has to self-refer and identify issues, which it will. If it operates properly, it most certainly will identify a number of issues. And building on Iain's point, we have actually written to the Secretary of State in a case that was a mess because this provision hadn't been made, where we had somebody arrested for a troubles-related matter. The custody time clock was ticking, and there was no process for the ICRIR to deal with that prisoner. So I had to get the Secretary of State to refer it in, and had people not been in the right place at the right time. And for me, some of those issues that, had we been consulted, certainly one about self-referral is, forgive me, simple language, it's a no-brainer because of what you come across. So that's how I think people tend to lose trust then with what is presented in front of them.
I probably, I'm not sure I necessarily agree that it needs to be referral. The Secretary of State has a list of cases that we had in Legacy Investigation Branch that we were going to look at and investigate. And I think that the Commission or whoever is charged with investigating should be given that list, and that all those families should have all those cases investigated. That was our intention. My understanding was from the Stormont House Agreement that was being taken away from policing so that an independent body could take on that, and now we're at a position where it's referral from the family. So I think, yes, we should have a mechanism to refer in, but it shouldn't be about referral. It should be about investigating where there are lines of inquiry. That's how you get an Article 2 compliant investigation by the state. That's what they need to do. So I'd like to see all those cases fulfilled, which was what we were trying to do. Not resourced enough to do it, didn't have the funding to do it, and we weren't deemed at times to be independent enough to do it. So the new body needs to take on what we had started and what we were trying to work through.
Thank you. Daniel Aldridge.
Thank you for all of your evidence so far. It's been really important to hear. So the ICRIR model was built around conditional immunity for people coming to it with information. I know some of you have talked a bit about that. With those provisions now deemed incompatible with the ECHR, how do you envisage participation by and truth recovery from, for example, non-state actors? And then just to follow up, how did Operation Kenova obtain information from paramilitaries, and how was the information verified? And anyone can jump in who wants to go first.
I think to a certain extent the issue, if I've understood the question correctly, I think there needs to be a separation. Often we keep going back to Stormont House Agreement conversations, that the Historical Investigations Unit that was proposed and the Independent Commission for Information Retrieval would have it had been challenging for both organisations to succeed, but I think that was the best model for them to succeed. And I think at the moment the Commission is somewhat confused as to what its primary role is. And we can talk about reconciliation, but no definition of reconciliation, and there's very scant information on reconciliation when you actually read any of the correspondence over the last number of years from different governments, actually. So I think the institutions should be separate. And you might recall when I talked about the command paper of July 2001, which was the precursor to the legislation, that effectively set out a set of intentions for the government that were quite worrying as a police officer and investigator about values and bringing people to justice, because it for me was setting a new set of terms of how to do business with criminal investigations, civil cases, coronial process in Northern Ireland, which I think was that felt quite insulting to victims and families. Many phoned me wondering what it meant to Kenova, and I think some of that was because Kenova, I'll be frank and I've said it before, was being so successful in getting information because we were being extremely robust about information recovery. So I think you need to separate those mechanisms. They brought them together so they could have this immunity where anybody came forward without their accounts being really tested, it would be accepted. And we know, and again it's mentioned in the Dillon case, Justice Coaten refers to this, where that was around protecting veterans from the military, from prosecution. And again, people look at that, and I've got many friends in the military. There were so many different stakeholders in Legacy disagreed with that approach. It was, again, a very narrow approach. Now that has fallen, rightfully fallen. It was always going to, I think, legally. I think there is an opportunity to separate those two institutions, and they will work far better. And there is something about, though, building on the Independent Commission for the Location of Victims' Remains, is to have that international agreement that exists with that organisation, with the Irish government and the British government around such a framework now moving forward. And I am encouraged by recent warming of relationships, and I think a positive environment where the Irish government and the British government are trying to work through a number of these issues. I don't know the detail, I don't know what they're looking at, but I'm encouraged, and I would encourage them to come up with a shared approach which would address some of the issues that's been spoken about in another question around information retrieval. And don't forget there are a considerable number of families in the Republic of Ireland that I've dealt with and Iain now deals with through Operation Denton. With regards to paramilitaries, I mean, I'll probably hand over to Iain because he's dealing with these things now, but we took the approach that's taken everywhere else. My background, we apply something called a SOCPA process, which is a piece of legislation in 2005, Serious and Organised Crime and Police Act, which provides you with a framework. What we were trying to do was mirror what you have in the United States around people cleansing themselves, telling you everything they've done, and then they might get immunity, they might not, they might get reduced sentences. It would give a framework for people to give intelligence without incriminating themselves necessarily, and we looked at the SOC provisions when dealing with people. And when dealing with people who had already been convicted of offences in Northern Ireland, we had a process where if we spoke to them and they started to self-incriminate, we would stop the conversation and ensure if they'd gone too far they were cautioned and withdraw so that they could have the correct legal safeguards, because we were trying to get information for families about other very catastrophic incidents during the Troubles. So it's legally it's quite a challenging environment, but again, legal frameworks exist to deal with them.
Could I just probe a little bit more on the piece that you said there about the amnesty? You think the amnesty piece was always going to be legally incompatible.
Yeah.
Why would any government push that through if the people were telling them?
Protect a certain category of individual. That's why they pushed it through.
They pushed it through knowing that it wouldn't be.
So I'm not a lawyer, but everybody, including people in the military, colleagues, friends of mine, had real concerns about that, and none of us could understand it. But it was because of the government of the day, their approach. And listen, I understand that, and we have to take account of what all the security forces did during the Troubles, the sacrifices, the loss. I talk about it in the Kenova report. But we as police officers at this table, we're held to a higher standard. And we accept the accountability that comes with it. And if we have acted illegally, criminally, we should be held to account. And the application of some of the security provisions around neither confirm nor deny have, without a doubt, in my view, allowed the security forces to escape with regards to them acting wrongly, and for that not to be held to account, so that accountability hasn't happened, and also for people who've been involved in criminality not to have been prosecuted when they should have done, because we've had this totemic approach. And when I first went into the PSNI, I was told that we couldn't, because I wanted to try and get more inquests into a position where they could be resolved before the cut-off date, and I was told that we couldn't do the work that I was commissioning because they were now under the stewardship of the coroner, and that couldn't happen. So that's wrong. So it worries me that they are advocating that to their chief constable. The second thing, they actually said if there's an agent involved, that attracts national security provisions. That is wrong. So some of the attitudes, some of the approaches to this, and a lot of that is recorded in the Kenova report, we've got to start trying to draw a line on this and move forward in a new way where we take account of national security concerns, but we also take account of everything else, and we're not disproportionate around our approach to national security concerns.
Well, I think I support everything the Chief Constable has just said. You asked about retrieval of information from paramilitaries and how you verify it. Following a report which I did in 2007 into the UVF in North Belfast, one of the brigadiers came forward as an assisting offender under the Serious Organised Crime Policing Act 2005 and was debriefed as an assisting offender. And that's a process, a proper process through which you can gather information and then you can determine and you can verify and look at existing evidence, forensic evidence, what was done, what was not done in the course of an investigation. Now, that man ended up admitting to, as I said, over 200 crimes. One of the problems you have with these people is that when they have committed very serious crimes, their credibility as a witness is somewhat compromised, and therefore there's huge balancing acts to go on. But there are processes. We don't have to go for anything as crude and as complete as an effective immunity. And I would like to say one thing, and I mean, I have a brother who served in the military, I have other family members who served in the military in Northern Ireland, and I know how much good work was done by the military in Northern Ireland, but I do know that part of the reason why the Legacy Act was passed was to protect veterans from prosecution. But the reality is that very, very few veterans have been prosecuted. And I know that this is being raised again as the renewal and the reform of the Legacy Act is being discussed. Very few of them were prosecuted and very few of them were convicted. And the majority of prosecutions and the majority of ongoing prosecutions were of people who were involved as paramilitaries in murder and serious criminal crime. So if somebody has committed an offence, the rule of law requires that it be dealt with according to the rule of law. And we can have no special categories, because apart from anything else, if we say our troops are not liable for their actions, then we put them in huge danger when we send them to conflict zones overseas, because that will be the expectation of how they might behave. So I think it's a profoundly important issue. One, that we adhere to the rule of law, and two, that we do not in future put our troops into a position of jeopardy.
Thank you, I appreciate that. Iain, did you have anything?
Just the referrals to the Serious and Organised Crime Act and the practices and the legal framework that exists around assisting offenders, I think that's an important point, because that is something that exists across the United Kingdom, and I think very often we almost look for bespoke solutions for Northern Ireland because of the intense complexity around it. But in actual fact, dealing with paramilitaries, the first response to that is, and again, I hope it's not overly simple, is very, very difficult, very challenging. Again, as Baroness alone said, the veracity of what they say, the motive for what they say. But actually, if you follow first principles, am I speaking to you as a witness? Am I speaking to you as a suspect? If I start as a witness, that can change, your status can change if you start to say something incriminating and you pause and you stop that. But the idea of an absolute immunity seemed bizarre when there was a model that had been used, recognising the need to get people who have been involved in serious crime, of which terrorism is a serious crime, and allow that further information to be taken through. So I do think at times, almost stepping back from it and bringing it back to first principles round about investigations, due process, fairness, would allow that engagement. And it's not unusual, and again, not necessarily in a counter-terrorism environment, but absolutely in a counter-terrorism environment as well, for investigators to do intelligence debriefs in live investigations, but also in historic investigations, where you would come and speak to somebody, not necessarily about their own conduct, but about some knowledge that they would have. But you need to be able to build credibility with the paramilitaries to do that. But there are processes that exist, and again, this is, as Chief Constable alluded to, the SOPO and the serious and organised crime provisions around assisting offenders. Perhaps that's something that's worth revisiting in the context of legacy in Northern Ireland.
I think all I would add to that is the current Act and everything that's happening, it needs to be deconflicted. So you need to separate this out, because we've talked here about how you can deal with this, how you can deal with witnesses and then suspects, how they can change, and on all the other provisions. So to me, the way that the Act is and how they have interlinked all the different parts, it's just incredibly confusing. And I think the Commission must be fairly confused, and the people working in it, about where are we going with this. So I think it needs to be deconflicted, and you start at that, and you could start to build something moving forward.
Okay. Thank you. Adam Georgie.
Thank you very much, Chair, and apologies for having to step out earlier on. All politics is local, and I had some constituents down, so I had to just go and say hello. But I've gathered from colleagues' questions and responses that the answers you've given have been both powerful and useful, so I shall read the transcript closely later. Now, transparency answers the truth. That's what many of the people I've met, we've spoken to, who've been impacted by the violence, the troubles, want to have, and that's, I think, why why information is so important. So I've got three questions, one for each of you, and Claire, do feel free to drop in if helpful. So Iain, how much impact would the Ministerial National Security Veto currently in place through the 2023 Act would have had on your ability to progress Operation Kenova?
It's difficult to assess fully, because within Kenova, and John, in some ways, or Chief Constable actually in his previous role at Kenova would be able to speak to this as well. The The process for our placing matters into the public domain, there was a protocol developed for that, which built in something we would call security checking. So again, I'm not disclosing any sensitive information, but this very morning I'm here. Some of the Kenova team are at Thames House with members of MI5, going through what we are calling our family reports. It's an element of the Kenova, the steak knife related work, where we want to give bespoke reports to families to give them some specific detail. So that commitment that Chief Constable Boutcher gave, again, it was, there was no model for that, there was no manual that Kenova was following. It came from John Boutcher's own leadership and commitment to transparency. But even within that, there was always an awareness that at some stage you would have to submit that for what we would call security checking to allow the representations to be made, similar as you would for maximalisation in any other context. I think what would be different, and it was never ultimately tested, although again John may be able to add to this, what had never been tested is that it was a matter of representation. There was no veto. So if there was a point of dispute, and potentially yet could be in matters I wish to put into the public domain later this year, if there's a point of dispute between the Cabinet Office, who would coordinate matters on behalf of government ministers, and the Kenova team, there is no, the Secretary of State doesn't have the ultimate sanction or veto on that. Ultimately, that would be a matter for us within Kenova to take that decision. So it was always envisaged and recognised. Again, we've touched upon this morning. None of us are in any way vandals around the security network. We're all products of it. We've all been deeply immersed in that for decades. We've always recognised that there would be potential national security concerns that need to be addressed. But again, as we've said, they need to be genuine issues of national security and not necessarily organisational embarrassment. And we would allow people to make representations, but ultimately that would be a matter for Kenova to take a determination on. So you wouldn't have this overarching veto sitting above it. But we always, right from the outset in the work that John Boutcher led, we always and continue to recognise the significance of national security, but it has to be authentic, and it can't be, there is no ultimate veto on what Kenova does, which differs quite significantly from the current provisions of the legislation.
Chief Constable, do you want to touch on that?
No, I mean, Iain makes a good point. Again, it's about the consultation. Families were really concerned about what any sort of report from Kenova would look like, as in its journey to being published, because of trust and confidence. So we wrote a draft protocol, which set out the steps that the report would go through before it was published. The first step, because people were concerned it would be written by lawyers from the security agencies, is that it said I would write the report. It's a Kenova report, it's our report, it's my report. The second thing is, which you would know as maximalisation or representation, where we'd negatively or adversely commented about individuals or organisations, we would write to them, explain what we were saying, and give them, if you like, a right to reply, which is just right and fair and proper. They didn't get the report, just the concern that we were expressing about their role. And then the third role after that, or the third function, was to do the security checking. And that was where, through the Cabinet Office, we gave them the report. Now, in the security checking process, what I'd done is I'd shared the report with two very senior barristers, both appointed by government to look at terrorist legislation. So vetted to the highest level, and if you like, establishment barristers. And they both provide me with an assurance there was nothing in the report that contradicted national security provisions. I then got a response that was quite a lot in the report that contradicted national security provisions. So obviously there was a contrast of view, but there's no veto for the Secretary of State. But it felt like I was having to box clever to get the report that I wanted to write, which wasn't going to threaten national security. And Baroness O'Loan used the term, the sky didn't fall in, published, I had to almost try to outwit the lawyers by saying, well, these two senior barristers have said this, so they completely disagree. And I'm delighted that the lawyers finally agreed that the report could come out in the form that it's in. And then the report had to go to the Public Prosecution Service to make sure there was no prejudice. And then it went to the Chief Constable of PSNI, and obviously that was a changeover period when I arrived, so the Deputy Chief Constable dealt with it to avoid any conflict of interest in the publishing of the report. But again, all that lessons learned is something that they may have picked up with regards to the NIO and the bill and how you would deal with reports, but nobody came to speak to us about it, which again I find, sort of disappointing but reflective of, I think, Kenova was seen as causing problems, actually, if I could describe it that way. And we weren't causing problems, we were actually trying to find everyone solutions, and very conscious of the difficult job of all of the agencies in making sure that we retain proper national security provisions.
Thank you. Baroness O'Loan, you've highlighted the issue of disclosure to ICRA with a reasonableness requirement that didn't exist in previous or other legacy investigations. Do you think the government will reconsider or should reconsider or may reconsider this provision as part of its reforms to ICRA?
Well, I would very much hope so, because if you have this provision that you can only reasonably request from somebody, the consequence of that is that somebody is going to make a decision about what's reasonable, and that can almost inevitably lead to judicial reviews about the decision making on the way. So I just think it was a silly provision to put in. It was an attempt to protect, I think, and it didn't work. I'd be very surprised if they do keep it. In fact, I almost understand that maybe they're not going to keep that provision. I wanted to just add something to what John and Iain have said about, the process before you publish a report, because it's a very lengthy process. If you've got a complex report, first of all, the fact-checking, and then the security checking, and then checking you're not going to impact on any ongoing criminal proceedings, and then the whole issue of national security. And they're all profoundly important, and it is important that everybody gets the proposed part of the report, but it's also important that they deal with it quickly and that they bring it back quickly. And one of the delays that we had in Kenova was simply waiting, and the Kenova report was published last March.
8th of March last year.
The 8th of March last year. Now, the families have received verbal reports about their individual cases. And I was speaking to a member of the Kenova families a week or so ago, and I asked them had they yet got their personal written report, because I have been asking about these written reports as a member of the steering group. And they told me no. And the reality is that the Security Service have had those draft reports since August. And we're now in April and coming to the end of April. And they have been through that process of checking and security checking and everything. So I think it really is incumbent on the Security Service, and I know they're very busy. I know they're coping with international terrorism and all the threats to the national security, but there needs to be somebody who can deal with these things and move them on much quicker. And the trust in the new processes, whatever they are, will depend on the disclosure of information, as I say in my response to the committee. And I think for that reason, we need to get these family reports out on Kenova, so that that part of the work is done, and then we get to a final report on Kenova, for example. It's not simple, but it is profoundly important because it goes to trust, and trust is essential for a stable society.
Yeah, I think that's absolutely right. Chief Constable, Baroness O'Loan's touched on this, I suppose, in many ways, with the answer we've just had there. But from your perspective as Chief Constable, in what specific ways would you like to see the national security and disclosure regime adapted in ICRA? Presumably, speeding up, no doubt, will be part of that. But I wonder if you could unpick that a little bit for us.
It's not straightforward. There's stated cases deal with national security, but what you won't find is a definition of national security. Lots of people have tried to get one, but the courts have addressed it to a certain degree. I think, and I've said this, and forgive me for cheekily referencing, There's 10 recommendations in the Kenova report. They were fudged when the report came out because there was a comment that there was ongoing legal proceedings, so the government couldn't comment. Those recommendations don't have any, I don't think, implication to any ongoing legal proceedings. So they need, I think, to be acknowledged and applied across the piece. And that would be a really positive step for this government around legacy. An acknowledgement, I think, would come from families and victims groups. In that, one of the recommendations is that we, and I give it to the Cabinet Office to do, to give it to, you know, the people responsible for national security, or certainly as the sort of the shop front for national security, the Cabinet Office, to review the provisions of NCND within the context of the security situation during the Troubles in Northern Ireland. Because without doubt, from what I've seen in my investigations, the provisions applied in a way that has stopped wrongdoing coming to notice and has prevented people from being prosecuted for murders. So I simply ask that the government look at that within the context of the Troubles, which is part of the United Kingdom, part of our democracy, to make sure that as part of the set of mechanisms to help move us all forward in legacy, that they review that. Now, obviously, because of what we've been talking about today, the approach currently is still very defensive and probably not what I would like to see. But if they could just see the importance of taking a different perspective, looking at it through everybody's lens, not just the security lens, and we will not allow national security to be breached or people to be put at risk or tactics to be revealed. That would not happen. If they could just see their way to approaching this more pragmatically and reviewing NCND within that context, I think it would be huge. Rather than the type of legislative work that I think they're thinking about doing. I think that would make a huge difference to people's trust and confidence. And for me as the Chief Constable of PSNI, the thing that still prevents, I think, nationalist Catholics joining the PSNI fundamentally is legacy. The headline's about legacy, it's about trust and confidence. That won't be built overnight, but it feels in some ways that we've gone backwards. I've spoken to officers who joined the PSNI from a nationalist background, and they feel we've gone backwards. I've spoken to officers who've been subject to distant Republican attacks because of the intimidation against Catholics joining, nationalists joining the organisation. And they often just come back to the issue around legacy, because that almost feeds as well the narrative of the distant Republicans, that we're still not addressing wrongs of the past. I will say this again, though, just to reinforce, I have seen remarkable work by security forces. But because of our approach, everybody thinks that everything has been done in a collusive way, that collusion exists in every case, and it doesn't. But our approach has fed that narrative, and we need to change the approach.
Can I ask, have you, obviously I don't expect you to share details of conversations we've had with ministers, but have you made those points to the Northern Ireland Secretary and to the Home Secretary and such?
Not to the Home Secretary, but I've made those points to numerous people that I met doing Kenova, and I've met obviously some very senior people, ministers, ex-ministers. I have repeatedly made those comments, but you come up against this wall, and I describe it in the Kenova report as the totemic wall of the security mantra. And I just don't think they understand that it's holding society in Northern Ireland back. And the last thing I will want to do is breach any national security provisions. I really, I must be very clear on that. But if we just adjusted the dials, if we all gave a bit, making sure that national security provisions were protected, I think we could make huge strides in Northern Ireland. And the PSNI as an organisation, we could see levels of trust and confidence in the organisation that were probably hoped for by the Patten Commission, the members of that commission, when they did the report and the PSNI was formed.
Yeah, could I just add one thing? One of the things I did as police ombudsman in reporting was to confirm suspicions which people had brought to me, and then to explain in other cases why those suspicions could not be confirmed and simply were unfounded. And I think that one of the reasons that we grew such confidence in the office was that we were able to explain a great deal. Now, I did come under a lot of pressure not to reveal things, but and a lot of judicial reviews in the early days. But I think that ability to confirm what has happened and to confirm what didn't happen is enormously important in growing trust in policing and security generally. That's just a final thought.
All people from all communities, I think is the point. Yeah. Thank you.
Okay, thank you. I've got some follow-up. Baroness O'Loan, you've said about the personal written report that the families have not had since last August, and that these are being held up, and therefore that's going to delay the final Kenova report. You said on the record, Sir Iain, that the Kenova report, the final report, there's a commitment for it to be completed by the end of this year. Do you foresee that this delay to the personal written reports is an issue?
No, my judgment is that it won't be, but only after some nagging, for want of a better phrase, and pushing from us within Kenova. As Baroness O'Loan said, we started submitting some of the family reports, I think it's 26 in all, back in August, and then there was another tranche later in round about October. And, bluntly, they hadn't considered them. So we route them through the Cabinet Office, and ultimately the Security Service take that review. On the back of some other engagement we've been having with the Security Service, there was a significant issue that arose round about this time last year, in fact, when both John and I were in front of this committee, when MI5 came to us and said that there was a whole load of new material that had not been disclosed regarding the agent steak knife, which really knocked us back. And then that took a period of assessment, and that will be something that I will definitely be reporting on in the final report. So with that level of engagement that we've been having with MI5 has allowed us, I think, for them to put resources into the family reports. I'm hoping within the next number of weeks that security checking process will at last be completed, and that will allow us then to distribute them to the families. Now, we've met with those families, we're in constant contact, and they've had a verbal update on matters that are very specific to their loved ones. And some of these are quite significant issues about who, what was happening in terms of some of the paramilitary organisations, but some of them are very specific. Some of them are facts that through Kenova, through the investigative team that John put together and the amount of information that was obtained, you can go to somebody and give them some specific fact about what happened to their loved one, either at the time of death or prior to that. And some of those very specific details can bring enormous solace to loved ones. One example would be that we spoke to a widow, and actually, through the inquiry that was carried out, we're able to show that her husband had the last rites administered to him before he was murdered. Now, he was still brutally murdered, and the impact on her family and the family was enormous. But she had a very strong faith, and she took enormous solace from that. So it was a very specific point that would be contained within that specific family report, and that's something we want to do across the other 26 reports. So I anticipate that we'll be in a position to distribute them within the next number of 3 to 4 weeks, and that will allow us then to move on to start to formulate the final report. And in that final report, I want to cover all of the work that Kenova has done. So there's initial work around about steak knife, but again, as been alluded to here, other investigations and reviews have been added to the stable of investigations and inquiries. So Mizzenmast was the murder of Jean Smith Campbell in West Belfast in the early 70s. Again, Kenova, the team, have carried out a thorough review on that and have fed back to the families. And then Operation Turma, related to the murder of 3 police officers outside Lurgan in 1982, where again, through quite incredible investigative work carried out by the Kenova team, a suspect for that has been identified, an ex-paramilitary. He has now been extradited to Northern Ireland, and that matter is now clearly into the judicial process, and the PSNI will run with that. And then finally there is Operation Denton, which relates to the allegations of collusion between loyalist paramilitaries and state actors in the early 70s in round about Mid-Ulster and down into South Armagh. And that was a review rather than an investigation. So that matter will report, and in the final report I will seek to pull all that together, pull out the learning from that, and again some of the issues we've discussed this morning will undoubtedly form part of that. But crucially, and again as John alluded to, it will be an update on the recommendations. What's happened to those recommendations? They were made back in March. I asked again in late 2024 for an update on where and how they have been progressed. I haven't had that update as yet. And then the other significant issue that I need to cover is the matter round about the non-disclosure of material from MI5 and the impact that has had. And again, it comes back to the issue that we've heard right from the outset around about trust and confidence. Because we've said we've seen everything, and yet suddenly 8 years into this significant investigation, all this material suddenly arises, and that has had a real significant impact on the trust and confidence of the families that we've been dealing with.
Should we be concerned, though, Iain, that there's only a finite amount of money there for Kenova, and that you may run out of time and you may run out of money?
Well, the Chief Constable of the PSNI has assured me that we will be able to get our work done. We're down to a very small core team of around about 10 or 12. It is demanding, not for me and for the rest of the team, but I'm confident we'll be able to get the work concluded. I have had engagement with the Northern Ireland office because under the Legacy Act, matters needed to be concluded, administrative matters needed to be concluded within, I think, 13 months, I think at the end of May, I can't recall the exact date. But obviously, my position would be, the reason I might have not been able to conclude the final Kenova report has been because of this significant intervening variable, suddenly, of all this material that MI5 hadn't held back. They've only recently concluded a review of their own, and we also felt that other matters in regard to Denton didn't actually fall within the Act. So I think my understanding at the moment is that there's an intention from the Northern Ireland office to extend that provision in the Act. It allows Kenova to finish its work, but I think other agencies such as the Ombudsman's office as well may need the benefit of that. So rather than having this hard stop, I think at the end of April, the end of May, there's an intention to extend that for a further 6 months. We will certainly finish our work within that. That's certainly my objective, Chair.
You don't think that MI5 are being deliberately obstructive then in order for the report never to come out?
I don't think so, but it's the timing of it. And I said that I wrote to the Secretary of State at the time that this material comes to light after the interim report is published by John Boutcher, after the DPP takes prosecution decisions not to prosecute, on the eve of the new legacy legislation coming into being, and suddenly all this material is brought to light. It was massively disappointing, it was massively concerning, but they have now conducted a review, an internal review that was carried out by a retired Assistant Commissioner of the highest integrity, and certainly she hasn't found anything untoward, but undoubtedly it's very, very concerning, the fact that this material was not brought to light when it should have been.
John, do you have anything to add?
No, listen, I think it's become a bit attritional with the lawyers, and I don't want it to be. I think we're trying to influence things so that people just look at things in a broader way and from other people's perspectives, and that's everybody involved in the Troubles. And I said earlier, if everybody could just give a bit and take account of everybody's different perspectives, then I think we could be, because of the current position with the two governments, we could be in a position where we could get something. It won't satisfy everybody, but we could get Legacy in a position where families can finally get the information that they've been waiting for a long time. But attitudes need to change. The structure definitely needs to progress. Stormont House Agreement was pretty much a framework that most people accepted, and I know there still had to be work to do on that. It's a wickedly difficult challenge, Legacy. But with the work of this Commission
and the new government, and I'm not criticising the old government, by the way, different people have different perspectives, but with the new government's approach, there is a real opportunity. But they're few and far between. And if this doesn't get fixed now, it's 25 years since the creation of the PS9 next November. If we are still in a position like this, trying to muddle our way through without any funding and resources to deal with legacy, I think it says a lot about the attitudes towards Northern Ireland society there, and how serious people are about trying to enable Northern Ireland to move forward.
Claire Hannah.
Thank you very much. There's a lot in all of that about the draft reports not being passed back from last August, and perhaps you've all been very, very committed to protecting national security and very professional, but it appears that it is over the potential disclosure of the name of the agent known as Steak Knife. You have committed to not naming that person, and you've referred to the dogs in the street previously, Baroness alone, and I think that name is very widely known. Would I be forgiven for thinking that the failure to return those is to put Operation Kenova in its place, perhaps, or to further suppress disclosure about the scale and the brutality of the partnership or the working arrangements between the security forces and the IRA?
I've written to the Secretary of State before Christmas, one for an update on the recommendations, which I published on the Kenova website, and then there was a second letter that had rightly had sensitive material contained within it, but I referenced it in my first letter, where I specifically sought permission to name the agent Steak Knife because I felt it was in the wider public interest to do so, and that was a follow-on from the recommendation that was in John's report in March. So that issue remains unresolved. I've offered to meet with the Secretary of State. I've offered to meet and brief him or other ministers or any other parties, I suppose, to advocate the Kenova position that Steak Knife should be named on behalf of the investigation, but potentially on the victims and families as well. So I haven't had a substantive response to that request to name him as yet. The other issues, as I said, the Director General certainly took the matter very seriously when this material came to light, and again, it's a matter of public record. That continued over the next number of months. New material, suddenly, there was other files were found, because I think they went back with renewed energy to go through their whole archive to find material. But all of that needed, Kenova to assess it and to look at its significance. And I will report on that in the final report. But undoubtedly, there's been a lot of interaction between Kenova and MI5 on the family reports. There's been a lot of interaction on the material that wasn't disclosed, and then clearly we've still got this matter about our request to name the agent Steak Knife, because material was shared with us under certain conditions, and that's something that I, as a head of Kenova, I'm not going to unilaterally breach, but I do think it's a matter in the wider public interest that Steak Knife should be named.
I completely understand that, and making the point that you have at no point attempted to overstep that. You expressed frustration last year that none of a dozen or more perpetrators against whom there was strong and compelling evidence were going to be prosecuted, and then further information became available after those prosecutions weren't brought. We've spoken about the wider confidence in rule of law. Should in theory then you be allowed to pick back up the investigative processes on the basis of that new material? And I suppose my question is there a wider issue here in confidence in the independence of the organisations involved in that, and I suppose in general the progress towards rule of law and adherence to it, if those prosecutions weren't made despite that evidence, and then further evidence suddenly magically came to light?
We've updated the DPP on the information that we've found as well. The prosecutorial decisions, rightly, are for the DPP and the DPP alone to make, as you know, and those decisions were made. You know, the deaths of key individuals and other circumstances undoubtedly are a factor related to that. I think our big frustration on the material we found is there was nothing that showed, you know, additional murders that should have come into the terms of reference. But the frustration is that there are lines of inquiry that can now never be followed or pursued. That had they been available to John and his team back in 15 or 16, 17, when they should have been shared, the potential would have been there to gather further evidence. That's something we can never know the answer to. That's what an investigation is. You go and you speak to people, and that takes you to other people, and it takes you to other people, and those have been denied. The significant issue, and it's a matter again, it's a matter of public record, and I've referenced this in different forums as well, is that it's also very clear that the security services' awareness of the agent's steak knife was very different from what had been presented both to Kenova but also into other public forums. And this idea or suggestion that, you know, the military were in charge of steak knife and MI5 really only had awareness when steak knife came to be relocated onto Great Britain, which would take probably, you know, mid to late 90s, being generous. That's not the case. This material makes it very clear, as one in some ways would expect, that MI5 had an awareness of the agent's steak knife really almost from the outset, which would take to the late 70s and early 80s. And I think that's a significant issue that, again, I will address in the final report. But it comes back to what Baroness alone, the Chief Constable, have said, what this committee have focused upon is the trust and confidence in the agencies of the British state in dealing with this matter, and it was very, very concerning. The Director General, I know, shares that level of concern, but the impact into communities and impact into the work that John's doing now, actually the impact into the work that we're continuing to do is significant, because when you do meet families and you say, you know, this is what we think are our findings, and that's different from something that they think, they say, well, you know, how do you know you've seen everything? Look what happened with steak knife. So it has been concerning, and it's been a very difficult issue for us to deal with.
Looking forward, as I think we're all desperately trying to do, but some of this stuff is so egregious and so current and so relevant to what we're talking about. But we've heard in evidence that scaling up Kenova would be the most cost effective and I suppose the most powerful way of addressing legacy. Could you briefly address how that might work in practice? That's a big question, but do you agree with that kind of a scaling up and a widening model of Kenova might be the best way to address investigations?
The short answer is yes.
Yeah.
Because Kenova works.
Yeah.
And it worked for a whole number of factors. Leadership is undoubtedly one of them. I don't want to embarrass John, but undoubtedly leadership, professional competence, rigour, stubbornness, you know, in terms of retrieval of information. When you're linking into other organisations, you've got to have your own people that are in there asking the questions, not people who work for the organisation that are giving you that information. So there's a whole series of I think, approaches that Kenova took in terms of being investigatively led, being very forensically focused, and having, you know, exceptional people within it. So as the investigative arm, yes, and then perhaps, as we've said earlier today, you know, if you go back into the Stormont House Agreement, perhaps have another body in terms of information recovery. But the investigative arm, I think, you know, Kenova's been quite remarkable, and it's the issues round about, you know, whether people have appeared in court or not. Well, there's a whole series of factors that were way beyond Kenova's power in regard to that.
Baroness, were you wanting to come in on either of those issues?
I suppose I never make assumptions about why people do things until I have the evidence to tell me why they did them, so I won't make any assumptions. I do think the time has come to name the agent steak knife.
Okay, I think it's one of those things of the process is catching up with public. Thank you. Thank you very much. And
Kevin Robinson.
Thank you.
Thank you. I still think it's bizarre that we're having a discussion about naming Snake Knife.
I agree.
Is it fair to ask that as somebody who believes he is named and known, but perhaps not officially, that none of us will be surprised should the decision be taken to name him? Or is that something that you can neither confirm nor deny?
So if I can take this one, we've always said we will follow due process. In many ways, I don't think victims have been given due process. So there's an irony here when you listen to the story, the history, the journey of legacy. Victims have been denied due process. We are applying due process. I have made representations personally to the Secretary of State about this. And because of this lack of information being provided, it creates conspiracy theories. So recently in a book that was published, things are said that are absolutely wrong. But it again traumatises families who've had conversations with Iain's officers and staff, who've laid out information to explain what happened. And then in the media there's a headline that Steak Knife was a group of people. All of that is wrong. Steak Knife was one individual. It's becoming pantomime and affecting the credibility of us as the security forces and government. And I would hope the Secretary of State will see that. But he will be receiving arguments from the lawyers who, I read the accounts given by those others who led legacy inquiries. The same organisation's lawyers will be saying you can't name him because in effect that will have a chill effect. I would argue strongly with my background it will not. And sometimes you almost lose the right to have that sort of voice when you have failed to manage informants and agents properly, when they have behaved in the way they behaved, which we set out in the Kenova report. Agents murdering agents. Agents being murdered when information should have been passed to prevent those murders. We talk about events in society that are catastrophic, such as, Grenfell, Hillsborough. And they are incredibly tragic events that all come to the forefront of our minds when we think about the seriousness of what can go wrong in society. I would question, is there anything more serious than what happened during the Troubles with the numbers that are affected? And yet we're still trying to scramble around and find a way forward. Mainly, I think, because of the defensive approach that's been taken. If the defensive approach was justified, I would support it. I genuinely would. And there has to be a line around national security. But we have prevented even uncontroversial information coming out. And the naming of Steak Knife is something that I would hope that Iain will be given permission to do. And if that doesn't happen, then I think it probably is the sounding of a bell to legacy not succeeding moving forward.
I just finally want to ask a question about the inclusion of individuals within ICRIR in the investigative process who have a policing past, be that with the RUC or PSNI. I personally find the argument repugnant and biased and politically prejudicial that they can not. But this committee has received evidence, including from the Northern Ireland Human Rights Commission, that suggests people with a policing past are incapable or should be ineligible to participate in legacy bodies. And can I just ask, from Iain and maybe then to your right, do you agree with the assessment of the Northern Ireland Human Rights Commission that anyone who served in the PSNI or RUC is incapable of performing their task in a way that's filled with integrity and professionalism?
I don't think they're incapable at all. I think they've got the skills. I think my own experience of officers in the RUC, officers in the PSNI, is that their professional standards and their ethics were as high as anywhere else you'll find across the UK and beyond. I don't think the question is about their capability. I suppose it is around about the appearance or how that might vest. My own view, and I think this is very challenging, because certainly one of Kenova's virtues, and undoubtedly we talked about the virtue of Kenova, one of Kenova's virtues was that there was nobody had served previously as a police officer in Northern Ireland. That's also one of the challenges, because it means that people are coming in, they don't have some of those cultural touch points that we all know are so sensitive in Northern Ireland, and Scotland has elements of those as well. They don't have some of the experience, but John took that view right at the outset, that he would do that to go and gather the trust and confidence of communities that had never had trust and confidence in state agencies in the past. But my own view, and I say this just as a suggestion, that there might be a distinction to be drawn between those who are in a position of commissioner and those that are in the position of actually being investigators and within the investigative team. So that process, that information that's gathered, the skills, the knowledge, the links, the experience that's been gathered can be brought to bear and can continue for the wider public interest. Having served in policing, they go and serve in the commission. But then, I suppose, the leadership or the assessment of that, if there's validity in that objection, perhaps you could draw a distinction between those that are appointed into commissioner roles and those that are in there as investigators. But are they incapable of discharging it independently? No, they're not. They're definitely not. I think this is more about apparent bias than actual bias, but as we know, apparent bias or perceived bias can be challenging as well. But they're certainly capable, because some of the best detectives and police officers I've ever met are people who previously served in the RUC and the PSNI.
And bias, in my view, should be challenged.
It is as I said, it's not actual. It would be apparent. Would be the challenge, I suppose.
Thank you. Nuala.
Thank you, Mr. Robinson. I'm just looking back to my evidence to you. I think I gave evidence to the effect that those who had held very high office in the RUC, in the PSNI, in the Armed Forces, in the Ministry of Defence, in GCHQ and in the security services should be excluded from any senior role in the legacy body. Because, as Iain has said, the perception would be that this was the old brigade coming in to run the new system. And that is a very damaging perception, and it was one which would mitigate against the development of any trust in the new organisation. In saying that, I know that there are men and women of great courage in all these organisations who serve with great honour. But the fact is that there have been very serious problems, and some of them at a very high level in the RUC, certainly from my personal experience. I mean, I've seen comments from very senior officers when independent investigators have come in, particularly from England, to do inquiries, wine them, dine them and give them nothing. So that sort of mentality which has been described, I think, is one that mentality of protection of the state, protection of the organisations within the state which must manage our national security. It's necessary that we protect our organisations, but it's not necessary that we allow people to hold very high offices in an organisation which deals with our legacy. I would say that as police ombudsman, I have police officers, former retired RUC and PSNI officers working for me at the lower levels.
So I should make clear why I took the decision that nobody with a background in the security forces in Northern Ireland will be part of Operation Kenova. That wasn't to do with competence or integrity. It was entirely because I was at the beginnings of an investigation where people had no or little trust and confidence in the security forces. And because of that, and because of my focus on trying to be Article 2 ECHR compliance, which requires independence, effective investigation, promptness, open to public scrutiny, and to involve the next of kin. The independence piece, I felt I needed to almost make a statement at the beginning that this was going to be different, and that's why I introduced a number of oversight mechanisms with independent people that I didn't know but had incredibly strong reputation. So I never met Baroness Nuala alone and called her out of the blue to explain I'd just been asked to consider doing this investigation, and could she help me with a group that I was going to set up to help us, support us, but also challenge us around how we conducted the investigation, hold us to account, really, and provide another level of reassurance around the independence piece. I think I agree with Iain, because of the size of the Commission, because of the volume of, if it gets the confidence and trust of victims, the volume of what they'll be dealing with, that volume isn't yet there. I think to have people in senior levels is probably a bridge too far. That's probably a challenge. But it shouldn't undermine the credibility, the character, the honesty, the integrity of those people, because they are excellent people. Who I've got complete trust and confidence in, but it's the perception to families, and it's been an argument that you may well have heard from other attendees at this committee, and when you've travelled around speaking to victims groups. So it's something that probably does need to be looked at.
I think, Chair, it's an interesting conversation in an academic sense, but we're not in an academic phase of this discussion. There are individuals in senior positions who have a past, and that's why I find some of this so repugnant, that it all seems very personal, actually, and it is counterproductive in terms of the pursuit of a settlement on legacy.
Okay, Baroness O'Loan.
Well, if I may say, the comments which I think have been made quite widely by a number of individuals about those who should hold high-level appointments in these in the ICRIR do not refer in any way to the individuals who actually hold those high-level appointments. I think everybody has the greatest respect for them as individuals and for the work which they have done. I think it is a perception issue and an independence issue and a compliance with Article 2 ECHR issue, a compliance with our own Human Rights Act. It's all those things, and they all lead, I think, inevitably to the conclusion that there should be nobody at a high level in the organisation, at commissioner level, senior investigator level, who actually has antecedents in the forces which, as well as paramilitaries, will be under investigation in the course of the work of the ICRIR.
I think all of that's accepted.
I just wanted to make the point that it's not personal.
Somebody is in a position
who
takes some of it, and that's why it's not an academic discussion. It's a live, real discussion.
Okay, Dr. Al Pinkerton.
Thank you. I'm cognizant of time, and I'm cognizant also of the Chief Constable's warning about an attritional approach, and I feel that we've probably worn you down somewhat today. I have a very simple question. The Chief Constable mentioned the fact that we all would wish the ICRIR to have the public confidence in it, and to have at least that function being served with some public confidence. The conflict of interest policy that the ICRIR have, do you know it? Do you see any inconsistencies between that and Kenova? And do you think if that conflict of interest policy were put on a statutory footing, that might lead to the kind of confidence that we would all wish for the public to have in that institution, or does it go far beyond that?
So I'm not close to this conflict of interest policy, and I know there's been discussions about introducing something into amended legislation. With the HET around conflict, there was a mechanism in place to make sure that officers and staff were not conflicted in what they were doing. And as I said earlier, because of the numbers that are required for such a body, there is an inevitability that people need to come from organisations in Northern Ireland who've served in the security forces. I also think there's a benefit. I actually think there's a benefit. I've explained the reason that I made the decision for Operation Kenova, which I think was the right decision. I still think it is, and we maintained it. We maintained that position. But the conflict of interest issue is something that I'm probably not close enough within the Commission as to how they're working through that. But it's something, again, that it's one of a number of issues that cause so many concerns that cumulatively, in the conversation we had previously, the bill had a bad start. That's why I mentioned the command paper in July 2001. It had a really difficult birth. And people joined the Commission without legal challenges being resolved as well, which again caused of itself, and I don't criticise them for that, people were trying to get on with the creation of the commission. But that's caused a lack of confidence in people's decision-making about joining the commission at that time. All of this, we all need to have some sympathies. I think Gavin mentioned this about an individual in a senior role. We all need to have some sympathies towards where we currently are. And we all need to, I'm going to use the term, give a little bit and see if we can find a way through this. But the conflict of interest issue is something I'm not close to within the commission.
Can you tell me, is it on their website? Because I've looked, I know about their code of conduct, but I don't know about a conflict of interest policy.
I think that's a very good question. I'm not actually sure where it's located.
Yeah.
Is it publicly available on the website? Yeah, we're being told that
It is. It's within their code of conduct. Which
So it's simply the statement about conflict within the code of conduct.
Yes.
Sorry,
So
I misunderstood the question then.
Yeah, it's within their code of conduct and standards that they will declare a conflict of interest. So there's a positive obligation on them to do that. What more legislation can add to that? I'm not sure. I mean, I think when we look at legislation, we just need to be careful how much we want to legislate for, because it's good in that it puts statutory obligations, but it's not good whenever you might need to change things, so because it takes a lot longer. So, you know, it is where I think we would expect it to be within their code of conduct and standards.
Okay, thank you very much, and I'd like to thank all the witnesses for giving evidence today. Order, order.